All right. Well, welcome back, everyone, to our last webinar for our spring series. Today, we're going to be focusing on pets and condos. We're so glad you could join us before we take a break for the summer, but have no fear, we're not going very far and we're not going to be away for too long. We will be back in the fall with our fall Lunch and Learn webinar series starting September 3rd. So for those that don't know me, my name is Sonja Hodis. I'm one of the many directors at CCI Huronia and a condo lawyer, as well as your moderator today. And as I said, today we're going to be focusing on the issue of pets in condos. This topic was actually requested by some of our viewers who took the time to send us an email and make suggestions for upcoming webinars. So thank you to those that sent in the suggestion for a pets webinar. We took your questions, compiled them to create the webinar today. So just a shout out to everyone that's listening. If you have a topic or a question you would like some answers on, or you would like to hear speakers talk about, please send an email to admin@ccihuronia.com and let us know what you would like the fall webinar series to cover. You never know, maybe one of your suggestions will end up in one of our fall webinars. I would like to also take this opportunity to thank our sponsors today. And as I've said on all of our webinars, and I'm going to say it again, and I just want to give a big shout out to Purcell Property Management, Aaliyah Associate Condo Lawyers, Atrons Council Insurance Brokers, Common Ground Condo Law, and AMR Group Property Management Specialists. Thank you to all of our sponsors. As you know, we're not able to put on these webinars free of charge for all of you without the generous support of our sponsors. So in case you don't know who CCI is, we are the Canadian Condominium Institute. We are an independent nonprofit organization formed in 1982. We are celebrating our 40th anniversary this year. We have chapters across the country, 8 alone in Ontario, and CCI Huronia is one of those Ontario chapters. CCI's main objective is education, although we also advocate for condos, and we represent all those involved in condos, from owners to directors to professionals, and we encourage everyone to work together. If you want to experience the benefits of membership of CCI and you're not currently a member, check out one of your local chapters. You can go to cci.ca, which is our national website, to find a local chapter. And if you'd like to join CCI Huronia, we would love for you to do so. We actually have a special membership drive that is expiring very shortly. And if you are a condominium corporation and you are not already a member, you can register for free for the next membership year, which starts on July 1st, but you must register by June 30th of this year to get your complimentary one-year membership for the upcoming year. Also, just a reminder to all of you that are members of CCI Huronia, the membership renewal notices have gone out, and there is a special renewal price going on for the first 40 days starting July 1st. Your renewal is $40. So $40 for 40 days to celebrate our 40th anniversary. Also, there's a lot of great resources on both our website, ccihuronia.com, and the national website, cci.ca. There is the National Resource Center, which you can access. And that can be available by just going to cci.ca and clicking on the National Resource Center tab, or you can go to our website and link directly from our website to the National Resource Center. Also, don't forget to follow and like us on Facebook. It's a great way to find out about our upcoming events. You can also go to our website and check up upcoming events there and register online for any of our webinars. And don't forget to check out our newsletter, Condo Buzz. It's available on our website. And I know Ashley Lamb has got a new issue coming out very shortly. If you've missed any of our previous webinars, our recordings of the past webinars can be found on our website under the Resource Content tab. So just a couple of reminders, just make sure everyone that you mute your phones so that we can get a clear recording. If you don't want your picture on camera or on the recording, please make sure that you shut off your video, because there is a chance that your image may be displayed. Also, just a reminder to everyone that the information today is general information and it may not apply to your specific fact situation. If you're a condo director and you want to use the protection of Section 37 of the Condominium Act, you will need to get an opinion about your specific fact situation from your own professionals. This webinar is not intended to provide you with opinions that would protect you under Section 37. In addition, the information today is current as of June 17th, 2022, and as things always change rapidly in condo land, the information provided today may not be relevant or applicable at a future date. So if you're watching this webinar after June 17th, 2022, please make sure that you contact your professionals to make sure that the information is still applicable. And finally, all references to the Condominium Act or other legislation are references to Ontario legislation. So before we start with our great panel of speakers today and talk about pets in condos, I want to start us off with a poll to find out what it's like in your condo when it comes to pets. So I'm going to launch the poll, and there are 2 questions there. The first question is, does your condo's governing documents, so that would be your declaration, bylaws, rules, ban pets or restricts them? And then the second question is, has your condo ever had to deal with a pet issue? And we'll give everybody about 20 seconds. All right, so we've got about 75% of participants responding. So I'm going to end the poll in 5 seconds. All right, and I'm going to share the results. And for the purposes of the recording, I'm just going to read out the results. So in terms of the first question, does your condo's governing documents ban pets or restricts them? Interestingly enough, only 3% of the participants today have a total ban in their governing documents. Vast majority, 88%, have restrictions, and 9% have no rules or restrictions with respect to pets. And then the second question is, has your condo ever had to deal with a pet issue? And 79% of people said yes, and 3% of people said no. I want to know where those condos are that never had to deal with a pet issue. That's probably a rarity, especially in condo land. Okay, so that gives us some information about your experiences and what you've got going on in your condos. So we're going to start off today with Ashley Winberg, who is going to give us some background in terms of where do you put these restrictions? Do you restrict? Do you do bans? Do you do restrictions? Sort of what should you be thinking about from a legal perspective? So Ashley, take us away.
Hi, everyone. I hope you can hear me all right. So corporations' governing documents usually consist of a set of rules, bylaws, the declaration, and policies. Now, any provisions regarding pets, the appropriate place to put those provisions would be in a condominium's declaration and/or the corporation's rules. Now, it's important if your corporation is considering implementing any rules with respect to pets that you review your declaration, because any rules must be reasonable, consistent with the Condominium Act and also with the corporation's declaration. Now, provisions in a declaration, on the other hand, don't have to be reasonable. And that is because the Condominium Act contemplates different treatment for provisions in a declaration in comparison to provisions in a corporation's rules, because the declaration of a condominium is almost like its constitution. It sets at the top of the hierarchy chain. So any provisions regarding pets in a corporation's declarations do not have to be reasonable, but provisions in rules do. In terms of pet policies, policies in general they're not enforceable under the Condominium Act. You can sometimes try and slip a rule in there referring to policies in order to try and make them enforceable. But policies are generally procedural internal guides for the board and for management. Now, I'm going to get into the common type of pet provisions. So the most common one that I see when there's an issue is a blanket pet prohibition. This is a complete ban on any and all type of pets. So if there is a provision to this effect, it should be in your corporation's declaration. Because if it's in your corporation's rules and you haven't had any issues with pets, like there hasn't been someone hasn't been injured by pets, or animals have not been found defecating on the common elements or causing damage or noise or nuisance, then that rule could be found to be unreasonable, because the rule has to show that it's being created for the purpose of promoting the safety and security of the property and prohibiting any nuisance. The second most common, strongest prohibition that I see is weight restriction, often for dogs. Often I see that no dog can exceed 25 pounds in weight. This, if your corporation wants to enact something to this effect, that too should be in your corporation's declaration, as opposed to the rules. You can obviously put in your rules as well, but again, it could be susceptible to challenge if your corporation doesn't have any evidence to suggest that larger dogs are posing a greater nuisance or to residents as opposed to smaller dogs or smaller cats. The third restriction is very common, restriction on the number of pets. Are people allowed to have one pet, two cats, two dogs? There should be a restriction. And that, again, ideally would be in the corporation's declaration, but could also be in the rules. Now I'm just going to get into more common rules that corporations that permit animals, pets, have. So you should have a definition of what a pet is if you're going to be permitting a pet. Generally, the standard definition would exclude any exotic animals, as well as dogs prohibited under the Dog Owners Liability Act. You should also consider implementing rules with respect to, where are the animals permitted to defecate on the common elements, if anywhere, as well as rules regarding owners and the responsible individual for the pet promptly cleaning up after the pet if they were to defecate on the common elements, and an indemnification provision requiring if they fail to do so, the corporation would be entitled to clean up the mess and then charge their unit back for the costs associated with that, in addition to any reasonable legal fees that the corporation may incur in order to collect those amounts. And an indemnification provision should ideally be in your corporation's declaration. You should review your declaration and make sure you have a very broad and all-encompassing indemnification provision. But again, if any rules that you're drafting regarding pets, that should, a more specific pet indemnification provision should be included as well. We also see a lot of rules with respect to the prohibiting of any grooming of pets. Pets only being permitted to be on the corporation's common elements if you are on, let's say, a high-rise building, for the purposes of going to and from the outside the building, always being controlled by means of a leash when not on the exclusive use common elements or in the unit, and stipulating that the leash has to be of a certain length, usually about 6 feet, or held in hand. Another very important provision is prohibiting any pets that are deemed to be a nuisance by property management or the board. And I would recommend that your rules, if this is going to be in the rules, clearly stipulate what type of behavior would constitute a nuisance. And this generally would include any unruly behavior causing personal injury or property damage. If an animal is found defecating on the common elements and the owner does not immediately clean up after the animal, if the animal exhibits any aggressive, dangerous, or potentially dangerous behavior, or causes any noise or nuisance that disturbs other residents on a consistent or intermittent basis. If the animal one night is acting up, that wouldn't be sufficient. But if it's a regular occurrence, that would be sufficient to constitute a nuisance. And of course, if the animal is prohibited because they're an exotic animal or prohibited under the Dog Owners Liability Act. And if an animal is deemed to be a nuisance, your rule should also include a provision that upon receiving written notice from the corporation, usually within 2 weeks, the unit owner has to ensure that the pet is promptly and permanently removed from the property. At this time, I'm going to turn it over to Jeff to talk about some of the practical issues that managers have with those rules that I just discussed.
And just before
Thanks,
Jeff,
Ashley.
Jeff, just before you start today, I want to give a big shout out to Jeff because today is actually his birthday. So everybody clap your
birthday.
hands
supposed
or
to do that, Sonja.
happy birthday, Jeff. I couldn't miss that opportunity. Thanks for joining us today on your birthday.
Yeah, thank you. So I'm going to talk about some rules that work, rules that don't work, and rules we all wish we had as property managers or directors who are managing the affairs of the condo corporation. So, a rule that owners should be in care and control of their pet at all times is paramount. As Ashley indicated, you want to make sure that you clearly define what care and control is. The pet should be on an appropriate leash and in hand. 6 feet is pretty common and acceptable. You don't want to see dogs on a 100-foot rope tied up in the backyard while they've gone grocery shopping or gone to work for the day, tearing up the common elements and potentially scaring other residents. Owners cleaning up after their pets immediately, not when the snow melts or when they feel like it, but right after the pet deposits its waste on the common elements or exclusive use common elements. Is often an argument we get from condo owners. Oh, it's on my balcony or it's on my deck. Well, it doesn't matter. It's still a common element. Considering a limit on the number of pets per unit, whether it's 2 pets total. That would be 4-legged pets, cats, dogs. If they want to have a aquarium with 6 fish in it, I don't think there would be objection to that. Restricting pets from certain common elements. You don't want pets in pool areas. You don't want pets in the fitness room. You might want to consider not allowing pets in elevators and restricting them to the stairwells. Larger buildings, consider prohibiting pets from the lobby, specified doors, alternative to the main lobby door for bringing pets in and out of the building. It just eliminates the interactions with visitors to the building that might not be familiar with the pet that can lead to other issues. Consider a ban on certain breeds of dogs that are known to be vicious and unruly, or at least a requirement for a muzzle when they're in the common areas of the building or the common elements outdoors. And very important, have a rule on penalties and deeming a pet a nuisance if rules aren't being adhered to. A 2 or 3 strike policy and then the pet being deemed a nuisance and removed permanently from the building is sometimes a necessary thing. It's difficult to do. It's sad to have to remove somebody's pet that's often like family, but it needs to be for the benefit of the entire community, not just one unit owner. Some of the rules that don't work, weight and size restrictions. They're very difficult to enforce. It's often not the size or the weight of the dog that leads to the issues. There are rarely bad pets, and more often it's lack of training and maintaining care and control of the pets by the owners themselves. Property managers aren't running around with scales and measuring tapes to measure pets and the common elements and or inside units. So it's more reasonable to have control measures in place rather than size and weight restrictions. Complete ban on pets is also not really well received in most communities. And as Ashley indicated, that really shouldn't be a rule. That should be in the declaration if it's going to be a complete prohibition on pets. It needs to be clearly stated to potential purchasers, and when they receive a status certificate, having that right in the declaration makes it far more enforceable. To try and bring in a ban after a corporation has been registered and changing the declaration might be a very difficult task. Many homeowners, whether they have pets or not, may not be in favor and likely wouldn't vote in favor of such an amendment because it can restrict the resale of their unit. And then there's the rules we wish we had. It's not uncommon to see a rule that says no bird feeders, but we'd rather see a rule that completely bans feeding wildlife. Bird feeders are a major issue, but other means of feeding the wildlife, whether it's putting bread out for ducks or swans or scraps for the raccoons or other animals, it leads to very significant pest control issues. We've seen bird feeders lead to pigeon infestations that can cost tens of thousands of dollars to clean up and remedy, and pigeons are very difficult to move away from a property once they settle in. So as much as you'd love to see the birds feeding on a bird feeder hanging off your balcony or patio, there are some significant issues that can come from that, leading to all sorts of other pest control issues. And then probably the rule we'd love to see the most: pet owners should be trained and proven to be responsible before having a pet, and provide a certificate of such training and responsibility. In my opinion, that should be the case for anyone who's adopting a pet in general. There should be some training. You need training and taking exams to operate a motor vehicle or to operate a boat. The same should be said for owning a pet. I'll turn it back to you, Sonja.
Thanks, Jeff. Yeah, it's usually not the pet's fault, it's the owner, right? So we got to train the owners. So you and Ashley have raised some, really interesting points. There was one question in the chat, and I'm going to send that to Ashley to answer. Somebody was asking about if you wanted to make a change in your declaration, what would the correct procedure be?
If you wanted to make a change in your declaration in terms of a pet prohibition or restriction, I would advise that you proceed under section 107 of the Condominium Act. So you would have to have the declaration amendment drafted, have a meeting, have to be approved by the board, and then you'd have an owners meeting to present that proposed amendment to owners. And then you would have to receive the written consent of, in that particular, if you're just restricting pets, it would be 80% of the owners of units at your corporation would have to provide their written consent in writing. And under the Condominium Act, there is no set deadline as to when that written consent should be received. However, at our firm, we generally recommend that the written consent should be received within 6 months of that meeting being held. And it's also important that the declaration amendment be pre-approved by the Land Registry Office prior to being forwarded to owners and that owners meeting being called. So that way, once the required number of consents are received, you can reach out to your corporation solicitor and it can promptly be registered.
Thanks, Ashley. So it's a little bit more involved than changing the rules, and a little bit more involved than changing the bylaws. But there is a process under the Act that will allow it to be done. So we're going to move on to two other speakers now who are going to give us a little bit of a different perspective in terms of some of the things that Ashley and Jeff said. And we're going to start with Ashley Lamb, who is our resident condo real estate agent here in Barrie. And Ashley, what are some things that you see from sort of a real estate perspective, from buying and selling condos? What are people interested in? What do they like? What do they don't like? What causes problems when it comes to buying and selling condos and dealing with pets?
Yes, Sonja, thank you. Pets, they're interesting because, you either love them or you don't, and they're either yours or they're someone else's. So it's a very personal thing. And what a lot of buyers, when we are going through condominiums and I'm showing buyers a condo complex, they really do watch, okay, how are the residents with their pets? What are they doing in the elevators? How do the hallways look? Why the hallways? Well, sometimes there's stains, and those stains are from pet droppings, or oddly enough, I lived in a condo once, and somebody on my floor actually let their cats out all the time, and their cats were just laying about in the hallways, and you'd come up off the elevator and you're like, oh, and some cats are friendly, and as you know, some are not. And some of these cats were peeing in the hallways, and you see these stains. So it's making sure that your dogs are on the leashes and you are following that, and you are showing people that these are the rules, instead of just, you can get the rules if you purchase a condominium. I always look into the rules on pets for that particular building, because they will vary from complex to complex. So if my client does have a pet, then I will call property management. But the other thing that you can do is you can make an offer conditional upon reviewing the rules, and you can review the documentation yourself just to see what the weight restrictions are, as well as how many. Most of the time it's one dog, maybe two cats or two pets, or so it can get confusing, and it does vary from complex to complex. So it is good to make sure that you understand those rules before entering into a firm agreement, because they are enforceable, as you know. And you can be put in a very awkward position, or put a board in a very awkward position, or of course the property management saying, look, these are the rules. I'm really sorry. You can't have more than one dog, and you have three. So you're going to either have to sell and move, or you're going to have to find a new home for your pets, which nobody really likes. That is awkward. But going back to stains on the carpet, if I'm a buyer and I'm walking through a condominium and I see a bunch of stains on the carpet, and I'm not a pet owner, or maybe I am, you're going to walk in and go, okay, well, when was the last time they changed the carpets? Carpet you're supposed to be able to have in the hallways for more than a couple of years. But are the residents taking care of the complex? Or are these carpets going to have to be changed regularly? Okay, well, if they have to be changed, I'm going to now be out of pocket to put money back into the complex and change these carpets. So that is something that buyers do look at when they are going through the building. Well, I was going to say something else there about the carpets. If you do have to change your carpet, and the board does come up with normally a few different options, and then the residents get to vote, make sure it's forgiving, because of course there are going to be accidents from pets, or spilling of drinks or coffee, or there will be stains. Try and pick a carpet that is a little bit more forgiving, a darker color, maybe has a pattern to it as well. When I have been in a variety of different complexes, some of the rules, and Jeff and Ashley did mention them, some things that I have seen quite a lot of course, the leashes in the complex at all times. I've also seen designated areas outside for dogs to do their business. And then I've also seen where you cannot walk through the lobbies, and you do have to either go out the back door or go down the side stairwells. I think Jeff mentioned that. One thing that a lot of newer buildings are actually incorporating into their common elements and amenities are actually doggy spas, which are kind of interesting. So you can actually walk right into the doggy spa, and they have a designated area, a tub, to wash your dog off, clean the paws off, before actually entering into the hallways and into the building. And I think that's actually, if a building can accommodate something like that, or even just a room, if it is an older building and you can't put a tub in there, but at least you have a room and you're, wiping off paws and everything before entering. I think that will help with a lot of the wear and tear on the carpets. One last thing that I did want to mention is really understanding understanding how important it is to respect other residents and visitors in the building. So although you might have your dog on a nice tight leash and your dog might be super friendly, I don't think that it's appropriate to let your dog jump all over somebody in the elevator. It can feel very awkward, and you don't know if that other person has a fear of dogs or what their background is. So just, knowing who your audience is, and if they initiate, who's your dog and all that, then go along with it. But it's really important to keep your dog close to you, making everyone else in the complex just feel comfortable and at home, and just respecting everybody else, really.
Thanks, Ashley. You've raised some actually really interesting points that, we probably weren't thinking about when it comes to condos and pets, but the points you raise actually kind of explain why we have certain rules in place to begin with, and why those rules are so necessary. It's about protecting the property, protecting the common elements for everybody's enjoyment. The control of your pet rules. I mean, that goes to your respect comment. So thank you for those insights in terms of what buyers are looking for. And hopefully that'll help boards and property managers understand what people are looking for and help them tailor the rules to their communities. All right, so now we're going to move to Michele Farley, who is our resident fire expert. And Michelle's going to talk about why we need some rules in terms of fire with pets in terms of fire safety. And I know a couple of years ago I had a case, and I spoke with Michele about the 25-pound rule and why we need that rule. And there's actually a fire safety component to that as to why a weight restriction is a reasonable rule. So Michele, thank you for joining us today. I know you're in the middle of a move. I'm not sure if we're going to get your video working, but we definitely have your audio. So go ahead, Michele.
Thank you very much. And I do apologize for not being on video, but the bandwidth here, I'm having a little challenge with. So I'll do my best. And Sonja, if you can just flag me if for any reason I freeze, but otherwise, this is not new. Save my pet. We hear it all the time. The New York Post printed an article this May called "Millennials Love Pets More Than Siblings, Partners, Even Their Moms," written by Aaron Keller. The article stated that a recent Consumer Affairs surveyed 1,000 pet owners and found that 57% of the participants ages 27 to 42 loved their furry friends more than their siblings. This should not come as a surprise. People love their pets. And in my experience, a lot of older people, that percentage might even be higher. So what do we do about our pets when it comes to fire? This question arises a lot more often than you think. Firefighting does not officially recognize pet rescue as part of their protocol. People first, then the building or structure. Knock down the fire and keep everyone safe. But questions still arise regularly from people wanting to protect their pets. What does the board do with a resident who is insistent their large dog be within the fire safety plan and listed in the persons requiring assistance emergency list? In one condo that I recently helped, a resident was adamant that her dog was a member of her family and able to use the stairs, and they were required to be helped to be evacuated. This claim became a major problem for the condominium, but the resident would not let it go. So we compromised, and I prepared a letter summarizing for the resident the priorities of the fire department, the priorities of life safety, and her option to stay or go, which includes her pet, as per the Ontario Fire Code policies, based on the risk in the situation she would be in her individual unit. That just wasn't enough for that resident. So the corporation compromise prepared an information sheet advising residents that they are responsible for their own pets and that they should include them in their own fire safety plan, what happens in their own home, and that in the event of an owner should not choose to leave their unit due to their pet or for any other reason actually, and there's smoke and fire in their area or in their unit, they are to call 911 and state their situation. The discussion about pets and fire safety plans has arisen often. The following quote was printed in an article by Quora and raised controversy over the response from fire professionals. A resident had stated, I have a sticker on my apartment door that says, in case of a fire, please save our cat. So if there was a fire, will the firefighters actually go in and get her pet? Well, the response from fire services was the following. Firefighters have pets too, and they regard them as part of their own families, and that the decals do alert them that there are pets within the unit. They look for people first, but they will help with pets if they can when they perform their search. And depending on the fire conditions, they will look for and rescue pets, but they can't risk firefighters' safety for the sole purpose of rescuing an animal. If there are no people in the building and conditions are deteriorating to the point where it is becoming unsafe to send firefighters inside, then no fire officer can justify risking human life to rescue a pet. The fire department went on to state that some pet owners will say they're going in to rescue the pets themselves if the fire department won't. But firefighters have a legal obligation to prevent anyone from re-entering a burning structure. Trying to go back in could get you tackled by firefighters and land you in the back of a cruiser until the fire is out. That's actually a quote from the fire department. In an article about the Surfside, Florida condominium crumble last year, the Washington Post printed an article including reports of firefighters on cherry pickers, which are large extension ladders, bringing water and food to pets while efforts were made to clear the building. So they try where they can. And in San Antonio, the fire department stated, who wouldn't want to read about firefighters bravely putting their lives on the line to save an animal? In January, they actually reported reviving 10 cats and 2 dogs trapped inside a burning house once the fire was under control. They even had received donated pet oxygen masks to resuscitate the animals. Some research has shown, though, that over the last 40 years, you used to have 17 minutes to escape 40 years ago from a fire, but now, due to all of our synthetics furnitures and the type of construction, you may only have 3 or 4 minutes. So what's the bottom line? Most fire departments say that it's really a judgment call whether or not to go in after a pet. If conditions are favorable, pets will often be taken outside while the fire is extinguished. But for condos, the condominium corporation is obligated to make all reasonable measures to protect people and property when it comes to fire safety. There is no obligation or requirement within the fire code for pets to be included in your fire planning. Residents can create their own fire safety in your home plan. Easy to use brochures can be downloaded from your local fire department. Their own home plan can include their pets if they choose. Stickers stating pets are inside are an option and can be posted within the unit's entranceway to notify firefighters of pets. No one should put themselves in harm's way to save their pets, but we all know pets are part of the family. You wouldn't leave a family member behind. So a plan to get your pet out with you or to secure them safe in a place if you can, if you have to leave them. All residents in Ontario are advised to follow the Fire Marshal's Office stay or go policy in the event of a fire. If it's safe to go, go. This includes taking your pets with you or making sure they're safe in a bathtub or somewhere that they can be contained. If it's not safe to go, stay and call 911 if you're trapped due to smoke or fire. It's your judgment call or whether or not to put your pet's safety first. And sometimes that's before your own safety. So,
oh, Michelle, we're losing you a little bit there. I think we lost Michelle. So Michelle, thanks for all that information. I was going to ask you the question about the weight restriction though, and I'll just share my experience on the weight restriction. As I said before, I had a case a couple of years ago where the issue was the board's ability to restrict the weight to 25 pounds. And I hear Jeff's comment about, it's hard to enforce that because you're not walking around with a scale. But I do recall when I was arguing that case, one of the pieces of evidence that we put before the court was that there is a reason for that weight restriction, and it's a lot of times and this is in a multi-rise building. It's because you have to be able to carry your pets down the stairs in the case of fire, because can you imagine being in a multi-story building with a bunch of people trying to get out in the staircase and having pets going down the staircase at the same time? So there is actually a safety issue when it comes to pet restrictions in terms of weight. Now, does that apply in a townhouse? Probably not so much of an issue, but when you're in a multi-story building, having big pets coming downstairs at the same time as people coming downstairs and not everybody having the same mobility, having issues with mobility does create a big safety issue. So I'm just going to throw that out there for some thought. And I don't know if Jeff or Ashley have some comments on that, but that's been my experience with why the weight restrictions are in place. Jeff or Ashley, do you want to add anything to that?
I agree with you entirely. That's why, and also sometimes noise complaints if a dog is very loud, and if it's a high rise, sometimes if they're running around the unit, it can cause a noise disturbance. But yes, primarily for safety concerns, as Sonja mentioned.
Jeff?
All I'll say is if you set a 25-pound weight restriction, don't be chasing pets around with a scale. If it looks like it's 25 to say 30 pounds, have a bit of grace there. Pets can change in their size based on diet and activity seasonally. As a cat owner, my cats put on weight in the winter because they're less active, and then in the summer months lean up. I know many dog owners have the same challenges, so be realistic.
Yeah, and there's information about breeds and what kind of weight a breed usually gets to, like a range. So there's also that kind of objective information. Some breeds are definitely going to be above the 25 pounds very quickly versus other breeds that sort of fall in that range. Okay, so moving on to another topic when it comes to pets, and that's the requests for accommodation. So if your condo has any rules or restrictions regarding pets, whether it's a complete ban, no pets allowed, or there's restrictions with respect to weight or the amount of pets you can have or what kind of pets you can have, there is an opportunity for a condominium corporation to have to deal with the Human Rights Code and a request for accommodation. And I'm going to talk about that a little bit. And then after, we're going to have Victor Yee, who's going to give you some updates on the cat cases from the Condominium Authority Tribunal regarding pets and what the cat is saying. So in terms of accommodation, the first thing to remember is that a request for accommodation doesn't mean that you're changing your existing rules, whether they're in your rules or in your declaration. What a request for accommodation is somebody asking to be an exception to the rule. So even if you grant the accommodation to one individual, that doesn't mean that everybody else doesn't have to follow the rules that are in place. Now, when it comes to requests for accommodation, that triggers the Human Rights Code. And we know, and there's no debate about this at all, we know that the Human Rights Code applies to condos, and condos have a duty to accommodate. That's the easy part of the accommodation request process. What gets more difficult is discovering whether or not somebody actually has a disability-related need that requires accommodation, and what that form of accommodation is going to take. Because under the Human Rights Code, the duty to accommodate is a duty to accommodate a need, not a duty to accommodate a want. And from the person's perspective of who's making the request, sometimes what they're asking is something that they want to happen, not something that they need to happen. So I want to just take a little bit of time to sort of give the brief overview on sort of how do you handle a request for accommodation, because the process that is followed is just as important as the end result, because under the Human Rights Code, you have a procedural obligation and you have a substantive obligation. So the substantive obligation is to provide the accommodation if a need exists. The procedural obligation is to investigate the request for accommodation and make sure that not only the person requesting the accommodation, but also the condominium corporation cooperate in this sort of investigative process to determine if the accommodation is going to be granted. So under the Human Rights Code, there are certain grounds that are protected. And when it comes to condos and accommodation requests, most of the time it is going to be under the disability ground. And so under the Human Rights Code, a person can make a formal request for accommodation, like they can come right out and say, I'm asking for accommodation. But condo corporations, you have to also be aware that somebody may be making a request for accommodation, but they may not be doing so directly. And that's still a request for accommodation, even if it comes sort of indirectly. So if you are writing a letter to someone to say you've breached the rules, you've got a dog and we don't allow dogs, and then someone says, well, I have a dog because it's an emotional support animal, but they don't come right out and say, I am requesting accommodation under the Human Rights Code. The fact that they have given you some information to suggest that there may be an accommodation issue here is enough to trigger the condo's obligation to investigate and fulfill their procedural obligations. So what are your obligations? Well, the first thing is to take all requests for accommodation seriously, whether they're made formally or informally. Once the request is made, if it's done verbally, ask for the request to be put in writing. And when you are speaking to the requester about their accommodation request, you need to find out some information and you need to ask the person for some information. So the first thing that we need to know is whether they have a disability under the Human Rights Code. We don't need to know what the disability is, and you're not allowed to ask directly what their disability is, but we need to know that they have a disability that triggers the Human Rights Code obligations. And the most important thing we need to know is we need to know what their disability-related needs are. And that's the question that you should be asking people. What are your disability related needs? Because once you begin to understand what the needs are, then you can take a look at the accommodations that are being requested. You should also be asking them what kind of accommodations are they needing, and if they have any suggestions for alternative forms of accommodation. That will allow both parties to try and find a solution. And if you have an owner or a tenant who is not prepared to provide you with the information that you're entitled to ask as a board, that would mean that they are not cooperating in the process. And there is case law to support non-cooperation means that there's no duty to accommodate. That doesn't mean that the corporation should not try and get the information. If you ask for the information once and you don't get it, it's highly recommended that you ask for it again and maybe 3 times. But there will be a point in time where if the person is not participating in the process, is not cooperating in providing information that they're obligated to provide, they will be deemed to be non-cooperative, and then the accommodation obligation ceases at that time. Now, if they do provide you with information, there are some things that you have to be very careful of. The information they're providing you with is medical, usually information, very personal information. So you have to be able to handle that information properly. Only those people who absolutely need to know that information, which would be limited to the board and property management, and perhaps the corporation's lawyer if they're assisting in the process. That information needs to be kept secured, and you only need to share that with people who absolutely need that information. It obviously is not going to be shared with anyone else outside of the board, property management, or the corporation's lawyer. The other thing that you need to do is to keep an open dialogue with the requester. And I always recommend that you have a meeting with the requester to discuss the accommodation needs. I don't know how many times we've had requests for accommodation, and we've been able to resolve them by actually just having a meeting with the person and trying to understand what it is they need and what it is we can do. And a lot of times we can figure out a solution without having it to take it too far. So part of that procedural obligation is to investigate the request when it comes in, to participate in the process, both sides participating. And then at some point, the corporation is going to have to make a decision as to whether or not they are going to provide the accommodation that is requested. And probably the hardest part of making that decision is evaluating the medical evidence that you're receiving and whether that medical evidence is sufficient. And that's usually where the big debate comes in. And that's not an easy task sometimes, but there's some things to remember. A note that just says somebody needs a dog, that's not enough. Because you can't understand from that note what the disability related need is. Maybe a dog is not the solution. Maybe it's the only solution, but you can't evaluate that unless you understand what the disability related need is. And so that's the biggest question that needs to get answered. And that's how you have to evaluate the medical information is, does it explain what the disability related need is so that you can determine what kind of accommodation can take place. And like I said, it's not an easy process. And that is something that you probably want to get your legal counsel involved with to help you maneuver through the documentation and the evidence that's being presented to you. So that's sort of how you handle a request for accommodation in a general overview. Again, I just want to remind everybody that there is the procedural obligation and the substantive obligation, and you may not have an obligation to accommodate under the substantive side of things, but you still could be found liable for damages, at least at the Human Rights Tribunal, if you fail to follow your procedural obligations. So those procedural obligations are really, really important. And again, you may want to reach out to your legal counsel to assist you through that procedural process. So, Victor, I'm going to turn it over to you now, and I'm looking forward to hearing what Kat has been saying about pets in condos. They've got that jurisdiction now to deal with it, and it'd be interesting to see where they're falling on some of these issues that condos are seeing when it comes to pets. So, Victor.
Thank you, Sonja. All right. Good afternoon, everybody. I'm going to be talking about 3 cat cases. So not cat as in the pet cat necessarily, but the Condo Authority Tribunal, the CAT. This tribunal has had the jurisdiction since October of last year to deal with pet issues. And so as we've seen the cases come out of the CAT, now everyone's getting a better sense of what the procedural obligation is that Sonja mentioned, and as well as a substantive obligation. So again, those are 2 separate obligations. And the first case I'm going to talk about is regarding the first substantive obligation. So how does a condo investigate the actual request for accommodation coming out from a unit owner? And so this case is Niagara South Condominium Corporation number 12 versus Spicer. And I think if Sonja could help me out and maybe post the citation to that case in the chat for everybody so they can go to the public database Canly and look up the case. But essentially, in this condominium authority tribunal case with Ms. Spicer, basically the condo had a no pets clause in the declaration and rules, so a complete blanket ban. And this unit owner, Ms. Spicer, was aware of that ban when she bought her unit. But the unit owner bought into the condo, moved in, and then claimed that her dog was an emotional support animal. And so ultimately, the CAT actually found that this unit owner did not provide sufficient medical evidence to the condo corporation to support her request for accommodation. So in the substantive obligation that Sonja was mentioning, that means the CAT said, look, the condo did its due diligence to try and investigate your request, but the unit owner herself did not cooperate in that investigation, and therefore the condo did not have an obligation to accommodate her emotional support animal. The unit owner claimed vague medical reasons. She just said, or her doctor said, that she was experiencing emotional distress due to separation from her dog. And then the condo wrote back to her and said, can you provide us with more medical information, but to basically show that you have a disability, because generalized emotional distress or anxiety is not technically a disability under the Human Rights Code. The unit owner actually refused. She asserted that her doctor's recommendation that she basically have a dog was sufficient. And the CAT, the tribunal, basically said, no, the unit owner's medical documentation did not indicate that Ms. Spicer had a disability which required accommodation. The unit owner also took issue with the fact that the condo corporation did not essentially have a policy of how to deal with these requests for accommodation, probably because the condo believed it had a blanket no pets prohibition. The tribunal actually affirmed in this case that each unit owner's request for accommodation should be assessed by the condo on an individual ad hoc basis. It should be an individual analysis. It should essentially be looked at individually. You might have a policy about how to look at the individual request, for example, how to request medical information, but the actual specifics of each request have to be individually looked at by the board. So the CAT ultimately ordered that the dog be removed within 14 days, and awarded the condo with, the condo, because the condo was the one who brought the application to remove the dog, with $200 in its filing fees, because the condo paid $200 to the CAT to bring the case. However, the Condo Authority Tribunal did not award the condo with any of its legal fees. The condo apparently spent around $10,000 plus in legal fees, and the CAT said no. Even though the condo technically had an indemnity clause in its bylaws, the CAT basically said, well, condo, maybe for compassionate reasons, you let the dog onto the premises while you were investigating the human rights request for accommodation. And essentially that indemnity clause in the bylaws only gets triggered if the unit owner has not complied. And the unit owner technically did not comply because you let the unit owner keep her dog during this process. Despite this, obviously, I would say maybe for compassionate reasons, for human reasons, for, just the fact of being a good neighbor, you might want to let the owner have the dog if it's already on the premises while you investigate, because the investigation process that Sonja mentioned can take weeks, right? Sometimes it takes writing to doctors, reviewing medical notes, talking to your own condos experts like doctors and whatnot about the medical evidence that you've received from this unit owner. So it is something that perhaps the CAT wanted to find a way not to award legal costs here, but I wouldn't really take that to heart. I do think that if the dog is already there and the dog looks like it's an emotional support animal, maybe let the dog stay for a bit and then, remove the dog or require the removal of the dog after the condo has decided on the substantive grounds of the duty to accommodate to not grant the exemption. The second case I'm going to be talking about is about how certain dog breeds can be prohibited. So as Ashley mentioned, there are certain breeds that are automatically prohibited under the Dog Owners Liability Act of Ontario. That's essentially pit bulls, and it's called a pit bull ban in popular terms. But there's a specific list under the Dog Owners Liability Act of certain breeds that are prohibited automatically in the province of Ontario. Now, some condos actually have prohibited certain breeds in their own governing documents. So the case I'm going to be talking about is called Wellington Standard Condo Corp 244 versus Polly. And this is a case that I think came out last week or earlier this month, sorry. And essentially in this case, the condo had a declaration which prohibited the following breeds. Crossbreeds are types: pit bulls, Rottweilers, Dobermans, Akitas, any sort of guard dogs, dogs originally bred for fighting, or such other breed as the board may determine in its absolute discretion from time to time. So that's in the declaration. So as Ashley mentioned, the declaration doesn't have to be reasonable, right? The bylaws and the rules of a condo do have to be, but it's in the declaration. Apparently it was in the declaration from the very beginning. So this was a pretty restrictive clause, saying anything that the board decides from time to time cannot be a breed in the condo, that's that. So the tenant actually moved in here with two dogs, one of which looked like a Doberman or a Doberman mix. And remember, Dobermans are prohibited under this condo's specific declaration. The CAT noted that there were no complaints about noise or aggression by the Doberman, so it wasn't an issue of safety or nuisance. It was just a prohibited breed under the declaration. The CAT also noted that there was no human rights request for accommodation here. So the tenant did not explicitly ask the condo to accommodate his Doberman, even though the tenant apparently told the owner that it was an emotional support animal. And apparently this tenant also mentioned it to the manager. But the CAT here said, well, the tenant never made a formal request for accommodation to the board. The CAT actually ruled, quote, a simple assertion of a need for a particular animal as emotional support does not suffice, end quote. So obviously, if it's a little more clear, if it is made, like, let's say, I think Sonja mentioned an indirect request, so a handwritten note, or there is some indication that it is an emotional support animal and this person has a disability, you should probably, as a condo corporation, probe that further, right? And try and get to the nub of what's actually going on. But if the owner refuses, and I've seen this happen in many cases, the owner just refuses to make a request for accommodation because some residents, believe that making a request for accommodation shows that, the person is weak, or admitting that you have a disability is weak in their eyes. They don't want to do that. So I have seen people say, if I have to make a human rights request, never mind. But yeah, in this case of Polly, basically the condo said, we didn't get a formal request, so it's not a human rights issue here. And the cat agreed. The cat actually ordered the dog to be removed within 21 days instead of 14. The cat did note that it can take some time to rehome a dog. And this is a little different because other cat decisions have given them 14 days, just 2 weeks to remove. This cat member said, never mind, let's just do it as 21 days, give it another week. The cat also said, look, if this dog turns out not to be a Doberman, because there was a little bit of a dispute about whether it was a Doberman or a crossbreed or whatever, the cat said, look, if the tenant can provide a veterinarian's note about what breed this dog specifically is within 21 days, fine, let the dog stay. But then basically the big kicker here again was that the cat did not award the condo with all of its legal costs. So in this case, the condo brought the application as well against the owner. And basically they asked for $10,000 plus as well in legal costs. The CAT only awarded about $1,500. And even though the tribunal recognized that that would mean the other owners, the innocent owners in the community, would have to pay the remainder of those legal fees, the cat kind of said, well, that's the way it is, right? That's how, if you have, dog issues, enforcement issues, human rights issues, it's kind of part of the condo's duty to basically, investigate, pay for it and all that stuff. So again, this is another case where the condo was successful ultimately, but did not get all their legal costs back. And this is a recurring theme, I think, for lots of condos in Ontario now, about when they bring an application to enforce their no pets or prohibited pets prohibitions, there is a question that we get a lot as legal counsel. Well, is the condo going to get its money back? And unfortunately, a lot of times we have to tell the condo, most likely you're not going to get all of it back. And unfortunately, that is a shift. It's a different way of thinking than how I think most condos are used to these days, because most condos expect that, look, if the guy is the one doing the wrong thing, that guy should pay. Unfortunately, the CAT nowadays is not necessarily going to go that way in every case. There are some cases that go that way, but there are some cases that don't. And especially when human rights are involved, and maybe not in this case, but at least in the first case, and the next case you'll see, the human rights issue and the angle that is presented, it really kind of pushes the cat to not award legal costs because it might be a legitimate request for human rights accommodation. And so ultimately, you don't want to be punishing those disabled individuals who need the pets with their thousands of dollars in legal fees. So this third and final case is an interesting one, because I did see in the chat people mentioning allergies. And this is a case where one owner brought this CAT application against the condo for allowing another owner to have an emotional support animal. In this case, is Tamo versus Metro Toronto Condo Corp 744. And this is essentially a three-way case. This was the unit owner who has the allergies, bringing the cat application against the condo, and also adding in the unit owner who has the dog. So in this condo's declaration, this condo basically had a declaration prohibiting animals or pets whatsoever, a blanket ban. And the unit owner who brought the complaint, Dr. Tamo, she actually deliberately chose to move in and buy her unit in this condo because of that no pets declaration. So everything was fine until obviously somebody eventually in this community requested an emotional support animal due to mental health disabilities. So Ms. Clancy did say that she had mental health disabilities, requested to have an emotional support animal, a dog, and the condo actually granted that exemption on human rights grounds. So they did the whole investigation that Sonja was talking about. They got medical evidence from Ms. Clancy about her mental health disabilities, and then eventually they ultimately decided, or the board decided, to grant the exemption. The complainant, Dr. Tamo, alleged that the unit owner's dog, Ms. Clancy's dog, was actually setting off her allergies, and she brought her cat application against the condo. The Condo Authority Tribunal actually, in this case, had to do a careful analysis of the medical evidence, because it really came down to one side's doctors versus another side's doctors. So the unit owner, a doctor herself, brought, I think, 3 doctors that she knew that were treating her for her allergies, basically. And the condo actually got a St. Michael's, kind of doctor, a top expert in immunology and allergies, to refute her evidence. And so the CAT essentially said that it was not unreasonable for the condo here to grant the exemption to Ms. Clancy, the dog owner, and that the dog was actually not causing undue hardship to the complainant. So remember, your duty as a condo corporation to accommodate someone's mental health disability is only to the point of undue hardship. And so the unit owner here, Dr. Tamo, who's complaining, she was saying that by Miss Clancy having her dog, it was causing her undue hardship, namely her allergies. The CAT ultimately preferred the evidence put forth by the condo from the St. Michael's doctor, and basically said the complainant's allergies, Dr. Tamo's allergies, were not likely actually triggered by this specific dog specifically. And that's really key in this case, because I can foresee another case in the future, perhaps coming forward to the CAT, where the medical evidence from the unit owner was quite strong and actually does pinpoint some sort of undue hardship. But in this case, the CAT, doing a very careful analysis of the medical evidence, said, no, that's not the case here. There was some evidence that other things could be triggering her allergies and not this specific dog of Miss Clancy's. The tribunal also ruled that the condo did not fail to accommodate Dr. Tamo's disability. So the other prong of argument that Dr. Tamo's lawyers brought was that she herself was requesting accommodation, namely not to have a dog in the condo building, and therefore in letting a dog in the condo building, the condo was failing their duty to accommodate her allergies, her physical disabilities of allergy, essentially. And in this case, going back to Sonja's little spiel earlier, because it's up to the owner, it is incumbent on the owner here, Dr. Tamo, to provide adequate medical evidence to prove, or at least indicate, that they do have a disability. She did not do so. So Dr. Tamo did not provide any medical evidence to the condo, despite the condo's lawyer asking her repeatedly through several letters over many months to please provide it to the condo. Dr. Tamo didn't produce those 3 doctors that she had until the CAT application. So that was already in the midst of litigation. So unfortunately, for her, the CAT actually said, well, you didn't produce the medical evidence before, so the condo wasn't obligated to accommodate the disability of Dr. Tamo, because Dr. Tamo refused to cooperate. And so this CAT case really does stand for the proposition, it's been in the case a lot before, but it does reaffirm the proposition that the unit owner requesting accommodation does have a duty to cooperate, to provide medical evidence to the condo, especially when the condo is asking for it repeatedly, like Sonja said, maybe 3 or 4 times. And ultimately, though, again, this is the theme here, the CAT did not award any legal costs to any of the 3 parties. So even though the condo was ultimately upheld, it was ultimately found by the CAT, the condo did everything right. You know, they allowed they allowed Miss Clancy's dog, and basically were not violating the duty to accommodate Dr. Tamo's disability because she didn't cooperate. But even though the condo was ultimately right, the CAT did not award anybody with their legal costs. And all 3 parties, so the condo, Dr. Tamo, and Ms. Clancy, all had lawyers, very experienced counsel. And then nobody got any legal costs, so they all went home and had to pay their own lawyers out of their own pocket. So ultimately, again, and this is a case where, unfortunately, because of the human rights issues, I think, that are at play, the CAT is very reluctant to give anybody any legal costs. So we'll see if that trend continues, but I don't think that will change very much. I think maybe Sonja, do you want to talk about the legal costs of the investigation process? So when a condo corp asks you, Sonja, hey, we got this medical note, can you investigate it? Who pays, essentially?
Yeah, thanks, Victor. And I think, at the end of the day, the corporation has an obligation to investigate a request for accommodation, and that's going to just be the cost of business of running a corporation. You're not going to be able to get those legal costs back from the owner. I think the only opportunity you're ever going to have to try and get legal costs in a human rights accommodation request is if the corporation is they're doing an enforcement, and the human rights accommodation is sort of a defense to the enforcement. Maybe that might open up some doors, but the whole human rights accommodation request process, that's not really going to trigger legal fees. But your comments about those cases made me think of one more thing that I wanted to raise, and it all comes down to the evidence. Like Victor's point about it really depends on what evidence is before the condo or before the CAT is so true, because and this is what makes these cases so complicated. And this is why condo corps, you do want to reach out to your legal counsel to help you navigate this in terms of the medical evidence. because you can't just take, say, for example, the last case that Victor talked about and said, okay, well, just because you have an allergy, you're never going to get accommodation. That's not true. It really depends on what evidence there is. You may have competing disabilities. What if you have someone who has a phobia to dogs and they're in a no pet condo? They bought a no pet condo because they have a phobia to dogs, and then someone comes with a dog. Again, it's going to come down to the evidence. So when you read these cases, be very, very cautious about the type of evidence that was before the decision makers. And don't say because it happened in this case, this is how it's going to happen in your condo, because it could be very different depending on what evidence you're dealing with. The other thing about evidence that I wanted to raise are these cards that we see all the time that say, they have a picture of the dog and it says it's an emotional support animal and it has a Canada flag on it. Those are not legitimate pieces of evidence to establish a disability-related need. That's not medical evidence at all. All somebody has to do to get one of those cards is pay $45 or $95 on a website, upload a picture, and declare themselves that it's an emotional support animal. That's not medical evidence. So when you see those coming through as the response to your request for information, ask more questions. That is not medical evidence. So we're almost at the end of the webinar. Just like all of our webinars, these topics, we could talk about them for hours and hours. But there was one question in the chat, and I'm going to throw it to Victor and Ashley to get your comments on it. But somebody was asking about whether we could put up video cameras to basically catch those animals that are defecating on the common elements. What are your thoughts?
Do you want me to go first, Victor? Or?
Sure, go for it.
Yes, you can. However, in the common elements, you can. However, it's advised that your corporation create an information management and privacy policy and post a notice advising people that they are on camera because there is some expectation of privacy. However, on the common element hallways, it's not as much. Victor, do you want to elaborate on the recent case?
So specifically, if you have a reasonable belief that there's a specific dog in a specific unit that's, let's say, defecating or urinating in the hallways, you technically could put a hidden camera up. So you can go on Amazon and buy like a smoke alarm that looks like a smoke alarm, but there's actually a camera inside, and put it up in the hallway. And for at least for a short period of time, I'd say, you don't have to necessarily notify people just yet, because really you're looking to enforce against a specific breach. You have this belief that this dog is doing it. And sometimes, to be honest, you're not going to catch them with the elevator cameras. They could take the stairwells. So sometimes you are allowed to put in a hidden camera, but by and large, if you're just generally looking for infractions, then yes, I would say you can put up cameras, but do a policy and post up signage to let people know that they are being watched. And sometimes that, to be honest, does actually just correct the behavior itself. Just the fact there's a camera, a visible camera, and a posted sign, that does usually, get people to stop.
Yeah. What about, what do you guys think about those DNA services that identify pets based on their DNA? And yeah,
that's a thing.
That's a thing. Yeah, you can. Wow. Oh, Jeff, you've had some experience with it. I see you rubbing your fingers together. They're very expensive.
In some cases it can be. We haven't actually experienced it, but I did speak with a vendor offering that service about a year ago, and there are some buildings in the GTA condo corps that require all pet owners to submit a sample for DNA purposes, and I think they charge that back to the pet owner, but last I heard it was about $120 a sample. So if you got a dozen pets in the building or in the condo corporation that all need to be tested, you're putting that onus on the owners. It's not a big deal, but then when you do find the feces on the common elements and send that away for testing, I'm told the cost for that is a little bit more. It's around $200. So it depends on the demographics and the nature of the building and the property. But some cases you could be collecting 4 or 5 samples a week. You need a significant increase in the budget. if there's a bylaw in place that the cost of that can be charged back to the unit owner, if found responsible, then it would offset it. But we haven't gone down that road just yet here in the Collingwood area.
Maybe the cameras are cheaper than the DNA tests. Yeah, but it is, I've heard about it. I haven't used it myself either. Victor, have you had any experience with the DNA evidence?
Yeah, what ends up happening usually is the condo boards explore it, and then once they put it out there that you're going to have to register your pets with DNA samples, the problem stops. Because people, after watching CSI and whatnot for decades, they recognize that if they let their dog poop sit and someone collects it, that DNA is pretty easily traceable once they've registered everybody. So it's like the camera system, right? Like if you put it up, you let people know it's there, people tend to stop the behavior, and then you get less chargebacks because people don't do it. Therefore, you can't really recover the money as easily. It's kind of a catch-22, right? You implement it, hoping to make money or at least pay off your costs by catching people doing it, and people stop doing it. So it is, I haven't seen any condos in my experience or my portfolio that have successfully implemented this. They've explored it, but they haven't actually fully done it. Obviously, I don't represent all condos. So it might be out there, but I haven't seen a success story just yet.
So I'm going to throw this out to the panel. What do you guys think about having a pet registry as part of the rules that owners have to register their pets? I've seen some condos do it where they have to like register the name and the breed and a picture. What are your thoughts on that? Is that something that condos should implement?
I like to include it whenever I'm drafting a set of rules for a corporation. I'll include the form, but I understand that procedurally it creates a lot more work for the managers, which I'm sure Jeff can speak to. But I do like to at least have a picture of the pet so that we can identify them if there's surveillance footage.
Jeff, Victor, any
Jeff,
comments?
procedural
Ashley
issues
Lamb?
with that?
We haven't had any of our clients put a pet registry in place yet. I could definitely see the benefits to it. However, as Ashley said, administratively, it especially in a large property, it could be a little cumbersome. And if you've got 150 units and half of them have one or more pets, then you're trying to compare those photos to what you might pick up in surveillance or the screenshot or picture that one of the residents has sent in saying, do something about this. And then it's the objectivity of the person trying to compare a portrait photo that the resident has sent in with their registration to a fuzzy picture taken by Mrs. Smith or the video surveillance. So it's until technology is better and software can do the comparison for you, I see a lot of challenges.
So I have definitely seen this, especially in high rises, I think, because there's so many cameras in a high rise. It is a difficult thing sometimes to compare a grainy surveillance footage photo of a dog. But the general gist of what breed or what color, kind of like having a car on surveillance footage, right? You can't really see the license plate all the time, but you can tell what make, what color, what car, what size of car, and match that up to the registry of vehicles that most condos have about the parking garages. So it is helpful, especially as an enforcement counsel. I like to have that information rather than not. Even if it's not definitive, it helps kind of indicate, more likely than not, it is, Bully the Boxer from Unit 308 versus the Chihuahua in 408 or something, right? So it is a little more helpful, but again, it's not definitive. And until, we get like HD AI facial recognition for dogs, it's a little tougher for humans to make that call.
I guess we're
It's
a little
definitely
bit
more cost effective and attractive than testing feces, though, with the DNA.
RFID tracking would be a better option.
All right. Well, we're almost near the end. If anybody has a question, post it in the chat. If you'd like to ask your question live, you can raise your hand and we'll let you ask a question live. But before we get to those questions, I wanted to put a question out to Ashley Lamb. In terms of, what can condos do to best communicate what their rules are with respect to pets? Because, we see a lot of these cases, and if you when it really comes down to it, it's because people are buying condos that have a no pet rule, but they have a pet, or people are buying condos that allow pets and they don't want pets. And so a lot of these problems could be resolved if we stop trying to put circles into squares and we match people up with communities that meet their own beliefs and desires and needs. So a lot of it comes down to the very, very beginning where Ashley's involved and is trying to find the right condo for you. So Ashley, what's some of your tips on what buyers could do to make sure they find the right condo, and what can condos do to best communicate to buyers, you know, what that community makeup is when it comes to pets?
You could always have a pet board, you know, or in the mail room, you can always have a pet board, just posting what the rules are. Whenever we do go into high-rise condos, we always do end up going into the mail room because I show my potential buyers what the mail room looks like, where they can get packages, because that's always a question. Sometimes they're looking for an extra parking spot, so we'll go there to see if there's a rental spot or a locker. So you could always just have a pet board, just reminding people that it is a pet friendly building, but these are the things that we do to make sure that people are following the rules. And you could always do something like that. But of course, it does come down to the professional showing that buyer the property and what type of dog they have. Do they go for walks? Do they not? Is it a big dog? Is it a little dog? What are their needs? And then, of course, finding out what the restrictions are in the condominium documentation. So, of course, making it a conditional offer. There are some buildings that I would recommend if they had a larger dog, for instance, than other buildings, just because of the space that the complex might have or where the area is. Not to mention the other thing that we do discuss is if you have a larger dog, then of course that buyer might be looking for a larger floor plan. Okay, well, what complexes have larger floor plans versus smaller floor plans and so forth. So it's also just knowing what the market is and understanding what the communities offer and figuring out what the needs of your buyer is.
All right, thanks, Ashley. Anybody else have last comments on that issue, on what do we think buyers or condos can do to better communicate what kind of community they are?
Sometimes after a status certificate is reviewed by a potential purchaser's lawyer and there is a prohibition on pets, if someone believes they're entitled to accommodation, if they have an emotional support animal, we oftentimes do receive correspondence from their solicitor asking for the corporation's permission whether or not the emotional support animal will be permitted. So sometimes if you are someone who has a disability-related need for which you require the use of an animal, and you're considering purchasing a unit at a pet-free building, for some reason, you can always reach out to the corporation solicitor directly vis-a-vis your lawyer prior to purchasing.
Jeff, Victor, any last comments on that issue?
Sure. Don't purchase a 450 square foot bachelor suite and bring 2 120-pound dogs into it. Find something that's appropriate. If you've got a couple large animals and you're bound and determined to be in a condominium, a townhouse style with its own yard might be a little more suitable for something of that nature.
Okay, Victor, last word on this.
I was just going to echo that. I do see sometimes people move into condos with a pre-existing large dog, and you have to wonder, like, somebody who likes dogs, like, is this the best thing for that dog itself? So it is I know that the market's tight. I know it's expensive, but sometimes, you got to take your dog's size into consideration when buying. Of course, I'm not a real estate agent, so Ashley, I'll give it back to you, but those are my last words on that.
Yeah,
I would say there's one last thing. Don't assume, like, if someone's viewing if I'm showing a property to potential buyer and we're in a building and you see a big dog, they say, oh, you can have big dogs here. I said, don't assume that. Like, that could have been one-off visitor. Just because you see it doesn't mean that's that's what's in the rules. Or that could be somebody that's in breach and has moved in, is in the middle of getting kicked out, right? So, just because you see it doesn't mean that's correct. So we do need to do our due diligence and go through the right steps before buying into the property.
Yeah. So, we've heard that in some of the case law recently too about, condos are communities, and sometimes you're not a fit for that community, and you've got to find the community that best fits you. And I think that's a good message that we'll sort of end this webinar with when it comes to pets, is find those communities that work for you and your pet, instead of trying to force yourself into a community that, may not like your pet. It's a lot easier than having to battle the community or having to move because things are not working out. So we'll leave it on that note. And we're going to end this webinar today. We're just approaching 1:30. So thank you to all of the speakers today. It was a great discussion. We got some great comments in the chat box about the discussion. So thank you for joining me today. Also want to take this opportunity again to thank our sponsors. And I'm just going to share the screen so that you can see our sponsors. Thank you again to Aaliyah Associates Condominium Lawyers, Purcell Professional Property Management, A-Trans Counsel Insurance Brokers, Common Ground Condo Law, and AMR Group Property Management Specialists. Thank you for all of your support. I encourage everyone to go to our website. You can click on the links to all of our sponsors to get to their direct websites. Reach out to them, thank them for supporting CCI Huronia and making these webinars possible. Just want to remind everyone to mark your calendars for our fall webinar series, our Friday Lunch and Learns, which always go from 12 to 1:30. The schedule for the fall is as follows: September 23rd, October 21st, November 18th, and December 9th. We are looking for topics and speaker suggestions. So if you have a suggestion, send an email to admin@ccihuronia.com. You can register for any of these webinars on our website, ccihuronia.com, under the events tab. A recording of today's webinar will be posted on our website within the next 7 to 10 days. If you haven't joined us on Facebook, please do so. If you're not on our email list and you want to get onto our email list, send an email to admin@ccihuronia.com and ask to be added to our list. Also mark the date for our upcoming AGM, which is going to be September 14th. More information will be available on our websites shortly. And other upcoming events at other chapters across Ontario. CCI Toronto has their case law update on June 19th. CCI Golden Horseshoe has their part 4 of their enhanced director's course on July 11th. CCI London has their June 20th golf tournament. Eastern Ontario and Grand River have no events listed right now, but you can always go to their website, cciEasternOntario.ca and cci-grc.ca, to find out about upcoming events at those chapters. If you want to know what's happening on the national level, you can go to cci.ca. So until next time, I'm Sonja Hodis, and from the entire CCI family to yours, have a great summer. We'll see you in September. And don't forget that CCI is your condo connection.